Let me just turn on the recording. So the recording is started. Please, everybody, turn on your video. And today I'm very happy to introduce our guest speaker and co-author and long-term colleague. I guess I was trying to remember back, at least since 2005, I think, is when we first met at the conference. Professor Richard Gruner, who teaches at the University of Southern California Law School. He was letting me know how. So you are wearing short sleeves under your jacket,
yeah.
right? You said,
yeah.
Okay, and he also teaches at the University of Illinois Chicago Circle Law School, and also has upstate New York connections because he worked for IBM both as an engineer and as in-house counsel. So you're in Armonk in New York City, is that right?
That's right.
Yeah. So, well, I'll turn it over to him. He'll talk a little bit, as I mentioned yesterday, about IP compliance issues and some other issues, and then we'll have time for Q&A. And so, Richard, welcome, and thanks for meeting with us.
All right. Well, it's my great pleasure to be with you today and to talk about some topics that may be a little different than some of the other things you're learning in law school. I hope to leave you with a different sense of an approach to not only transactional lawyering, but systemic lawyering, meaning approaching a client or a set of transactions that are known to be ones where there are many repeat players. And because of the repeated aspect, you want to think about not just the one in front of you, but the future ahead in a somewhat different way than you might in addressing one legal controversy. And with that, let me pull up my slides. Here we go. And
so I can see them. I hope everybody can see them.
Excellent. Well, as the title suggests, I'm going to be talking about building IP assets, but not just a single transaction that might involve building an IP asset, but rather building IP assets over time. And what that leads us to is thinking about effective IP management. IP management or in fact, legal issue or status management is an area that is not very well addressed in law school. It certainly was not addressed at all in my era in law school. And even as I've been trying to teach in law school, it's often neglected, greatly neglected. It's even neglected in practice because much of the management aspects of developing IP, it's not clear where responsibility lies, whether it lies with organizational managers, with the legal department, somewhere in between. The answer is that to do it well, both the legal specialists and the business managers have to be attentive to this and work together on it. And you'll see some aspects of that in the course of the talk. I want to address three main topics. These are highlights of some of the material you saw in the readings that I believe Professor Ghosh has distributed. These are what I would say are the three most important features of the material addressed in those readings. And I'm also going to expand on what was in the readings too.
Yeah.
Excuse me?
Okay, I'm not a meeting right now, but I can chat a little bit.
Okay. So the three topics are how we should think about success in IP management, how the...
okay, oh yeah, that's fine.
All set?
Thank you very much. Bye.
So how we should think about success, how parties should pursue IP management and building assets systematically, what would be the components of practices aimed in that direction. And then finally, how to think about IP management as a feature that can be molded to ensure future success of the organizations or individuals involved. And thinking about how the IP will be used in the future and the status in the future changes what parties need to do right now in very important ways. All right, well, starting with the first of these topics, and let me say before I leap into the heart of the talk, I'm setting this up for about a half an hour, at the end of which I'll be happy to take questions on either the topic of the talk or any other topics related to transactional lawyering that you'd like to get into. I have been involved in transactional lawyering, both as a practicing lawyer That's what I did at IBM full-time and in very interesting ways. But I've also taught a lot about transactional lawyering. One of the case books that Professor Ghosh and I have written about is all about transactional lawyering as it affects IP. And so I've been very interested in all aspects of transactional lawyering in the IP field. So success in IP management, a little different than one might measure success in many areas of the law and legal practice. You learn a lot about law in law school from cases and disputes and how people address disputes. But when you start to think about IP management and asset building, I suggest you should start over in your perspective. You should take a very different view. IP management and IP asset building is a peculiarly forward-looking and constructive type of practice and type of activity. In other words, one can construct new facts, construct what one specialist called hot facts rather than cold facts. And I'll tell you a little more about that in a minute. But in terms of measuring success in IP management, what one should aim for and what, as a lawyer, you would hope to help your client gain is some attention to creating assets that complement the business in the future. In other words, if a business is going to be engaged in certain activities, it wants to have IP interests, first of all, that protects as much of the exclusivity of that future activity as is possible, at least the areas that are valuable in the service or a product it's providing. It wants to provide that product or service without free riders. Free riders is a general phrase for people who have gained the benefit of your activity without paying for that benefit. And in a business context, that means somebody who immediately replicates your product without paying any of the development costs. IP interest can prevent that, but only if you perfected the IP interest in a proper way, looking forward to the business that you hope to engage in the future. Another aspect of forward-looking use of IP is sometimes to create differential features of your product that nobody can replicate and then market the distinctive features of your product, knowing that the emphasis on those features cannot be taken up by anybody else. That's more of a marketing strategy, but the IP interests are key to knowing which features of your product that nobody else is just going to step up and duplicate. And then finally, you may, or a business may develop IP in order to set up IP interests that help it help it counteract the IP threats of others. So if some activity requires joint IP, the other party has key IP that you want or your client wants, it's important to have an IP interest that they want, and then you can do some sort of cross-licensing that gets both parties where they want to go. Aside from those kind of uses of IP to promote or further some other business core, it is also possible to create IP for its own sake. Some technology developers create new IP and then immediately license it or transfer it to others, and they make their money, their living out of being able to make that IP transfer. It only works if there's an IP interest to transfer. And the transfers can be in two flavors, an overall assignment of the complete IP rights, or slow transfers through license agreements where it's essentially a pay-for-use kind of environment. That's another version, though, of transferable assets where the key is setting up a valuable IP asset in the first place. So those are both forward-looking thoughts about what IP management success would be about. Preparing the right interests, making sure you protect the interests as they come around. The third goal is in fact much like what you see in other dispute resolution settings. That is trying to prevent the IP interests of others from being an impediment. But again, there's a forward-looking aspect of that because often even existing conflicts with the IP interests of others can be worked around or minimized in their significance. And I'll say a little bit more about that later too. So even in the avoiding infringement of other parties' IP interests, there's a forward-looking aspect to what success would entail. These are objectives that are in fact primarily forward-looking. They're about the future, intended future of the client. And in that regard, the future hasn't been written yet. An important feature as a transactional lawyer is you're almost always dealing with hot facts. You hopefully have a client that's come to you before they've committed to a course of action, or even if they have committed before they've taken much of that action, in a way that allows the client to do something different that might better their position. And in that regard, the distinction between hot facts and cold facts is much like the difference between hot lead and cold lead. Cold lead is set into a shape, you're stuck with the shape, you're stuck with what it is or isn't. Hot lead can be molded, can be shaped in ways that are more attractive, more beneficial. And the same way you should think about facts as a transactional lawyer working with a client, where the client is making decisions about future actions, is that your mission is to hopefully help them make choices and take actions that will maximize their position in the future. In that regard, IP interests, hopefully in a well-run organization or in the hands of a client that is attentive to legal issues, IP interests will be considered, taken into account throughout the decision-making of the client involved. And it's important that they take these things into account early, because the way they do various things can often maximize their IP interests or avoid the IP interests of others. And in some extreme cases, where it's clear they need IP interests of others and those interests, licenses or other access to the IP is going to be difficult to gain, it may be that the intended action they were looking to is just not worth the candle anymore. They should know they're heading for a train wreck. And given that, they sensibly will say, you know, maybe we ought to spend our time somewhere else. And so avoiding those train wrecks is part of the preventative features of a transactional IP practice, but it's also part of the success in good IP management, surfacing the issues early and then giving the client the choice, but making it an informed choice. All right, so that hopefully gives you a sense of how to think about success in IP management. This is part of transactional lawyering, but it is very different than I think a lot of people initially think as they study at law school. I didn't come around to this line of thinking until I was with IBM for a while, and we were often dealing with clients or managers in IBM that were repeat players. We were talking to them not only about the problem they had right now, but they were going to have that problem again and again and again, and how they could address it next time it came up. So moving to the second topic for today, if you know you have a client with repeat instances of a certain IP generation or certain IP potential conflict, it makes sense to think systematically about what should be done about this. The types of practices that I'm going to be talking about now, and catchphrase for these practices is an IP compliance program, make the most sense where you have repeat players. And there are two different ways you might have repeat players. One is that your client is going to engage in a certain kind of transaction over and over and over again. And it's known that that's just going to come up as a repeated matter. It makes sense to have a procedure for that repeated situation so that not only can you get it right from the beginning, but maybe you can learn something and get it better over time. And so those two features make sense to, or make it desirable to think about a systematic approach to how those transactions are going to be handled. The other reason for a system and other setting where systematic practices make a lot of sense is where you have a horizontal repetition, meaning you have multiple organizations that right now are engaging in the same kind of transactions, probably in parallel, but many times. And so working out not only a system again, but maybe some comparison between the various instances of the practice makes sense as a means to both maximize the knowledge you've got in terms of good effect across the multiple branch offices, but also if one branch office has encountered a problem for the first time, that knowledge can be applied to the benefit of the other branch offices before they stumble on it. And so that notion of systematic communication and improvement is valuable as well. All right, so getting into the components. So what would a systematic approach to IP management look like? There are two important features here. One is that there's an overall scaling principle. The scaling principle is think about or measure the risks of IP loss and scale the IP management system to the IP interests at stake. And the risks that are of interest, we'll talk about in a minute, but relate to both losses due to conflicts of IP of others, but also lost opportunities, IP that might have been captured but wasn't. And so some sense of where are those risks and how important are they to the organization is going to drive everything else. Where the risks are big, if you've got a movie and there's a certain story and you need the rights to that story, that's an absolutely fundamental IP risk. On the other hand, if there's some logo that you might want to use in a scene in the movie, but you could shoot around that logo and not include that scene or not include that shot, getting a license to use that logo, it's a risk, but it's not a big one. It can be worked around in a way that is not fatal to the big picture of the completion of the movie. So risk-based system is a fundamental pervasive feature of these programs. And again, that's a scaling principle. How much do we want to do? The other is what particular steps might be involved and where would we learn about those steps? Well, it turns out in developing IP compliance systems in particular, there are two areas of background that we can now draw on. One is that these are, in a sense, a variety of quality control systems. And you may think of quality control as ensuring that parts coming out of an assembly line don't have defects. Well, that's one instance, but anytime something is systematically done and there's a quality measure for whether it's been done well, you can have a systematic approach to ensuring that that goal of perfect quality is, if not attained every time, at least attained as often as possible. That's a quality control system. The manufacturing line is just an instance of such systems. In our setting, IP management and avoiding unnecessary losses of IP interests and avoiding conflicts with IP of others, those are the quality goals of an IP management system. The other area where there's specific history of legal compliance programs turns out to be in the criminal law area. In the corporate crime area, corporations are expected to systematically prevent their employees from engaging in criminal conduct and carrying out company business. And there are standards in the organizational criminal law area that already turn on the minimum features of a well-constructed compliance program. It turns out that the main area that these have come into play are in penalty setting, when a company has either been convicted of a crime or is liable for a regulatory offense. The scale of the penalty that is imposed will depend on whether they were trying to prevent what happened through a reasonable compliance program, and there are standards for what a reasonable program must include. So from that area of the law, there are actually concrete standards to look to that give us guidance. We still have to take some effort to bring them by analogy into the IP area, but they are well thought out about how to contain legal liability, and we just need to think about how that might translate into preventing IP losses or losses of IP opportunities. So when we think about IP risk, I mentioned earlier, we want to not only think about risks that a client is going to be successfully challenged through infringement of somebody else's IP interest, but also lost opportunities. And what is going to affect the size or magnitude of those risks relates both to how often are they going to come up and what is the consequence to the business involved if they come up. Once those two factors are taken into account, the IP management activities and how close to perfect the company or other organization wants to come in IP management will be scaled to how big a consequence there is if they don't achieve their goal of proper IP protection. And this notion of IP risks is not a static type of analysis. IP risks are a moving target, unavoidably so, for two reasons. The risks that the company faces in the IP area depends in part on what it wants to do, and what its business activities are, or what they hope to be, will change with business circumstances. No business stays static. They hope to grow. That may involve new IP risks. They may find new competition. That may involve new IP risks. So changing business circumstances drive changes in IP risks, and that in turn necessitates a updating of these kinds of risk assessments and a further updating of the compliance program features that responded to risks. The other reason that IP risks change is that the laws change. And a new law can create very significant or inconsequential risks for a given business, but somebody needs to think through, gee, it's clear the law has changed. Does this matter for this particular business? What are the risk consequences for this particular business? And that's a periodically changing assessment as well. All right, well, once there's a sense of the risks involved, organization or any other party thinking about these systematic management steps needs to get down to concrete steps. I'm rather rapidly going to go through these steps to give you an idea of how they might be structured. The particular details are going to depend a lot on the clients and the IP interests that might be involved. First and foremost, there should be standards and procedures for circumstances where IP assets or risks are going to be present. In other words, where it's predictable that there's a chance to either construct a new IP interest or a setting where it's clear that IP that may be owned by others is being used by the client involved. In those settings, rules can take two different forms. One is a direct do this, do that, do this other thing. In other words, where it's clear that certain steps are needed. Maybe that's make a disclosure to counsel so he or she can start a corresponding patent application. If there are steps you want taken every time when there's a certain stage of activity achieved, then the rules will read like a list of actions to take. If there are circumstances where there may be problems, but it's hard to know exactly what their form or significance is, then the rules are going to sound more like a triage requirement. If you engage in this activity, if you're going to meet with competitors, this is a classic. If you're going to meet with competitors, you must review the meeting involved with antitrust counsel, because any meeting with competitors, at least for certain businesses, raises risk of antitrust violations. But since the nature of the meeting isn't a cut and dried when you can't state specific rules for those meetings, it's only that is a genre of high risk and you should get counsel involved. Another feature of the systematic IP management, if the system is well constructed, is that top organizational managers are not only involved, usually periodically reviewing how the IP has been managed over, say, the past year, but in addition, there's a specific high-level manager who is the manager, the business person responsible for IP management and using IP well in that client organization. That ensures that there's attention given, both periodically by the full range of periodically by the full range of top management, but specifically by one party who knows they will be held accountable regularly if there's a major IP gap. A related point is that if parties have demonstrated that they're not attentive to IP and have dismissed it as inconsequential, it's important that they not ascend to top management, because that's just a problem waiting to happen. They've revealed that they're not responsible in this dimension of business management, and it should be a negative factor in shaping top management. Communication and training relates to programs that train employees to do the things they need to do to get the IP interests right. If there are steps that certain people, for example, engineers, as they develop a new product or new device feature that might be patentable, they need to know that they need to get to counsel for at least a review before they disclose it. Otherwise, in all likelihood, they will have lost the chance for a patent. So steps like that directed in practical terms to the people in the client organization that need to take the relevant action are part of the rules set up. But if the individuals don't understand those rules or have not been informed about them, they don't mean much. And so the communication and training is the follow-up on a practical level on getting the standards and procedures into the hands of the parties that need to follow them. Auditing, monitoring, and evaluation is about two things. One is parties just not following the rules that have been set up. And the other is about the adequacy of the rules and procedures to gain the IP results that the company or other client hopes to achieve. It may be that the whole system was ill-conceived in the first versions. That can be revealed by auditing. It may also be that it was well-conceived, but it's not being executed correctly. That can also be achieved by auditing. In general, these things are not usually developed well in their first versions. Things are left out or things are unexpected. And so monitoring and as you'll see in a minute, improvement are key aspects of this. In some circumstances, auditing and rule setting, auditing, and improvement are at the heart of the compliance program. There's an article of mine that I would encourage you to read about how one can think of IP management in terms of lean management principles. For those of you not familiar with lean management, it's a common managerial approach in high-tech industries and some other settings where it's not clear how to develop a new product because the whole technology involved is very uncertain. And it's also maybe unclear what the customer set really wants. So the companies engage in a lean management approach, which is not lean as in don't do much, it's lean commitment to anything before you've tested it. And so if you take that concept into IP management or any other legal management, a lean commitment to a new practice where you can gain feedback and learning from that practice may be ideal in many settings because you don't really know how to direct employees to gain the best legal result, but you can learn that over time in an organization that is engaging in similar practices that can produce feedback. So that's part of the monitoring thinking and approach as well. Incentive and discipline refers to make this matter to the individuals who have to take action. If they can dismiss IP, they will, because they're busy people. I mean, one of the things that I encourage you to remember that your clients and the individuals within your clients, if they're companies, even if they're good people, they are prone to overwork, over assignment, over stress. They're incentivized to try very hard on certain things. And if IP management is not one of those things, it will get put to the back burner. And so there has to be some assessment and stake in things like monetary rewards, things like salary setting and bonuses, as to whether IP was properly addressed, particularly by people like engineers who are the key custodians of IP at certain stages of company activities. And finally, improvements in IP management over time. That's part of the learning process I mentioned before. The whole IP management system can be thought of as a learning cycle. Periodically, you see how you've done and you improve. And then second of all, episodically, if you have an IP management failure, something goes materially wrong and it's recognized, that failure needs to be taken as a learning experience and assessments made about, well, what went wrong and how can we do the same thing differently in the future when we encounter something similar. All right, third major topic, I'm running almost on time, and I'll wind this up very quickly, is positioning IP assets for future success. And this involves thinking not only about the nature of success as I described it earlier, but thinking about the evolving nature of success as a company or other IP producer moves forward. as businesses change, the source and content and importance of IP will probably change with it. In certain businesses, as business may have started as a creator of one kind of content, and within the range of its content, one little area turns out to be very attractive to customers. Now, as it creates only content in that one sub area, different types of IP protections might be valuable to it. So that kind of change in the content of the business leads to a need to rethink where the valuable IP lies. Another future-oriented feature of how IP might change is in how many startup businesses conceive of their IP and their futures. In high-tech settings, it's often the case that a company is perfecting a new technology and maybe bringing it to market, but only in a very small way. And in the course of that, they have an opportunity to gain patents, but they don't have much in the way of resources. And it may occur to business owners that if they're left to their own devices, it may not, first of all, they may not be able to pay to get the patents, but second of all, what will the patents mean if they don't have resources to enforce the patents? And patent litigation is extremely expensive. So if they're put to the test against an infringer, if they can't enforce the patents, what's the point? Well, the answer to that is that's the wrong thinking. A little business that has a new technology and gains a patent and has people interested in infringing that patent should think like a big company, because in all likelihood, its route to success is that it will be a takeover candidate down the road. If it's got a technology that has got some market traction, they haven't fully developed the market yet, but they've shown that at least an important subset of customers think this is really important as a product, they can go to a takeover buyer and market that package. In other words, the company as a package, having not only a proven product, but the IP rights that ensure that the bigger company can take over that product and market it vastly and ensure that nobody else can come in and produce a competing product because the IP rights of the developer will prevent that. So the IP rights should be thought of as if the originator is the big company, because it can market itself to that company and gain the benefits of transfers to the big company. And so that's what I'm referring to here when I refer to think big while acting small. Another aspect of future thinking about IP is that if something comes up in the course of the core business activities that the originator really doesn't want to pursue it at length, it can spin that off by transferring the IP to another business that does want to pursue that use of IP. So, for example, this shows my age, but once upon a time, there was liquid paper. I don't know if any of you even know of liquid paper, but liquid paper was a great product when we were typing documents. So you could literally paint over the mistakes and then type on it again. Well, this was developed by a secretary who got terribly frustrated with her having to retype pages, because that was the only way to get a perfect page in a certain era. And she worked on this formula for a while and came up with this wonderful product, liquid paper. And so as it turned out, her employer let her pursue it, and she made a tremendous fortune out of that. But that's an indication of how in everyday activities, there's new IP being created from sources you might not think of in your company. And the company didn't want to pursue this IP interest itself. And so she went off and was able to go a long ways with it. New IP that is created by happenstance is actually quite frequent. And the question usually is there any reason that company really wants to pursue it? And often the answer is no. The other source of unexpected IP is within the business core, and new marketing ideas that are addressing the core business activity that are not appreciated as an important feature initially, but as customer reaction develops, it's clear that that is a distinctive approach to marketing and has some IP traction accordingly. The degree to which this is going to change in the future and be used more should flavor the present degree to which efforts are taken to try to protect that IP, given its future significance. So in conclusion, very quickly, I want to recommend to you the type of transactional lawyering that is behind this kind of IP management. Working with the business executives on these kind of management processes often involves counsel in key business decisions. It helps the clients change and build value rather than just cleaning up after problems and mistakes. It aids businesses in avoiding major pitfalls, train wrecks, as I used the phrase earlier, as well as expanding its success. You can be truly a part of the team in a very positive way. And finally, and to me, the most important is you meet wonderful people. You are working with some of the creative originators of IP that are among the most fascinating people in the client organizations that you might be working with. And so I recommend this kind of practice, and I hope you'll have those kind of experiences. And that's the end of my prepared presentation. I'm happy to take questions on this or other topics.
Well, thank you so much. That was a great talk. Covered so much. It's a rich area. We could probably do a whole course just on this one topic, because I could see all sorts of directions, and I've got lots of questions. And I should mention, I do talk about liquid paper in the first semester of this course. This is a 2-semester course. Yeah, so I use that as an example when we talk about IP created in the employment context, to talk about shop right. I assume the employer in that context would have gotten a shop right, or I don't know if they actually did or not, but I think we discussed that in terms of shop rights and things like that.
Yeah,
so
yeah, I mean, they would have gotten to use liquid paper on their premises, but I think they were she was obviously not employed to create new IP products,
right,
so it's not clear she had an obligation to assign.
Right.
And it is an interesting case in that regard. Even if she had the obligation to assign, many companies will allow, once they decide they don't really want to pursue the business opportunity, they will allow employees, essentially the company will waive their rights as sort of an employment satisfaction gesture. I mean, it's not a loss to the company, and it is supportive of their employees.
Right, and I think and I think some of us might know, the person you're talking about is Mike Nesmith's mother.
Yeah.
Mike Nesmith of the Monkees, who passed away. Now we're really getting into the really ancient history. Really ancient history too, right? Who are the Monkees?
And what you didn't know, if you grew up with the Monkees as I did, is that Michael Nesmith, I think, was loaded through that whole process, because his mother was a very successful inventor.
Right. So, but thank you again. This is great. I have a lot of questions, but let's open it up. Are there any questions from that people have for Professor Gruner? I'm sure people have questions. It doesn't have to be specifically about this. It could be about other aspects of practice or courses to take, or let's see if there's anything in the chat. Well, maybe I could see. I'm just trying to make sure I'm not missing anybody. Well, let me seed some questions then. I have tons of directions we could take on this. One thing that might be directly relevant is that for their first project, we're doing it on the choice of business entity. LLCs versus corporations versus partnerships versus sole proprietorships. I think we may have shared that with you. So did you want to talk a little bit about things like IP holding companies? I know, for example, GM, about a decade, I think last decade now, time passes so quickly, but I think they transferred a lot of their IP into one company, an IP holding company. Yeah. Did you want to talk a little bit about that in terms of organization?
And there are a number of reasons to do that, and this is not as much about what kind of company as much as what combination of companies might be helpful. The use of an IP holding company has been useful in a couple of different ways, one of which was tax planning. Now, the US has taken some actions to try to scotch this approach, but it has been the case that putting IP ownership in foreign countries has allowed companies, including Apple, is I think notorious for this, to license their own technology such that their profits from selling an iPhone, the licensing component, the amount they're paying for the IP that's embedded in the phone, lodges in Ireland or some other foreign country where the corporate taxes are low. And if you know your tax law, the payments of the royalty become an expense in the United States, so they would negate US income. The money that is paid as a licensing fee ends up as income for the Irish company, but corporate taxes in Ireland are low. So the net tax, if you can manage where the payment lodges, manage that into a low tax country, that's advantageous from a tax standpoint.
Right.
And one way you do that is to create a IP holding company in the low tax jurisdiction.
Yeah.
The other factor that or other reason that I understand that the holding company approach has been used is to clarify where you've got multiple subsidiaries to attribute expense amounts in accordance with how much use there is in each of the subsidiaries of a given commonly used IP factor. So, for example, one of the insurance companies in a set of transactions I teach in my IP licensing course, one of the insurance companies set up a separate company to hold title to the insurance management software that several subsidiaries use, and each of the subsidiaries paid a royalty amount in accordance with with how often the software was used by that subcomponent of the company. And so it became a mechanism to administer and scale the separate royalty use charges in that way, all still within one actual enterprise.
Yeah. And so when you're thinking about corporate compliance or IP compliance specifically, forgetting about the holding company, I mean, one way, I guess another aspect of the holding company is you collect all your IP in one entity for management purposes. I think that's done in the entertainment sector, isn't it? I think a lot of performing artists and musicians do that, right? In terms of there may be tax advantages, but it's also putting all your eggs in one basket so you can keep your eye on the basket.
Well, or sell off the basket in one fell swoop. You've been seeing that a number of leading older artists have sold off their catalogs in the last couple of years.
Yeah.
Springsteen, Dylan sold separately his recordings and his songwriting copyrights. And each of these have been multiple $100 million transactions, staggering amounts.
Right.
The reasons for that are quite interesting, and I didn't get a sense of it until I spoke to a friend who's a former entertainment industry lawyer. And my question was, why now? Because it's been impossible to sell these catalogs off. And this is basically a multi-copyright assignment transaction, the bundle of many copyrights. Think of the many songs that Dylan has written or Springsteen has recorded and written, all sold in one transaction, in one case to Sony, and I've forgotten the other company, but one of the big companies like that, for hundreds of millions of dollars. But why now? Because obviously the artists could have done this in past years. And the answers are, interestingly, I think twofold. Is the possible future uses of, let's say, the Springsteen catalog as both the recordings themselves and also as background material for new movies and other original scores is of tremendous value to a company like Sony or another content distributor. And so the buyers are paying top value all of a sudden, or at least in recent years. The other is, interestingly, the artists may not be getting the income that they were formerly getting. It turns out for these big marquee artists like Dylan and Springsteen, touring was the big source of income. And we
Right.
kind of know what's happened to touring in the last 2 years, and who knows when that will fully revive again. And so the mass tours that were themselves sources of many millions of dollars have gone away, and the artists may have thought it was time to find a different source of big income.
Yeah, very, very interesting. But when you're thinking about compliance, IP compliance, also in the way you've described it, in terms of implementation, are you thinking about, so many of our students have had business associations or taking other business classes. And so there's a whole literature about committees and, what the obligations of good faith are for committees and things. I don't know of many cases that have come up in the IP compliance area that overlap with that. But in terms of the implementation, how would you see this working? You're thinking about sort of an IP committee. Would this be a chief IP officer? Would this be in the in-house counsel office, or would this be split between? I think there are obviously lots of different ways to do it. But just curious what you're.
For example, it helps to take a specific context. So let's assume we have a high-tech company. The approach to IP interest is going to be driven out of the counsel's office, but with the involvement also of the technology manager organization, technology management. So you need the involvement of the managers of the engineers, but the content origination probably from the counsel and whoever the IP specialist is among counsel. In some cases, that's going to be an outside lawyer, but the company's counsel will be the one to organize the effort to set out a compliance program and then periodically review that program, with the involvement, though, and accountability of at least one senior manager who is the figure within the senior management group that is understood to be in charge of IP management success.
I see. Interesting. And are there technology management firms? We're talking about one of the things we're going to talk about later on in the semester here are new modes of legal practice, especially with legal tech. And so are we seeing technology management firms, sort of hybrids of attorneys and maybe MBAs or technology managers, or is a lot of this happening in-house or within the firm,
within the company? At least as I understand what's developed in Silicon Valley, is that generally there'll be an in-house lawyer, maybe a couple, that within that in-house group, somebody is an IP specialist, because in a high-tech world, the ultimate value of the company is so fundamentally tied to the IP, and certainly the ability to be a buyout candidate down the road is tied to IP. The ability to get VC funding is tied to IP. There's just, ignoring IP is a fundamental gaffe. And so the in-house departments, if you have more than one lawyer, or even if you have just one lawyer, that lawyer is going to have some background in IP and therefore be the first line of advice. As they need specific IP help, they're going to get outside counsel, but the technology that is at the core of that company is also at the core of the legal practice of the general counsel of that company. So if they're not an IP specialist themselves, they're going to regularly be seeking some help along that line.
Yeah, interesting. Because one of the things we've been talking about as well in this first project, this first part of the class, is also sort of the legal ethics issues and PR issues about attorneys. Obviously, part of this is taking a business interest in their clients, which might be related to what you're talking about, but also attorneys giving business advice and some of the malpractice issues that might arise when the attorneys don't make it totally clear whether they have their attorney hat on or their MBA hat on, especially nowadays. And not just simply an MBA hat. I mean, we have attorneys with many advanced degrees, engineering and so forth. So Did you want to talk a little bit about that as well? Or?
Yeah. I mean, there are ethical issues that should limit parties in giving business advice that is disguised as legal advice. But in fact, at least when I was at IBM, we would always signal, this is not what the law requires, but this is what I would suggest as a good business sense. We would always throw in our legal 2 cents. I'm sorry, our business 2 cents.
Right.
For two reasons. One is we were often the detached person in the room. The other people the business people in the room, they'd been working on a project for a long time, or they had a real stake in going a certain direction. They just weren't going to see the other business related features that might suggest a different decision. The other was we were well informed about these transactions. We were insiders to the transactions. Almost nobody else was as well informed except the actual parties conducting the transaction. And so if we didn't speak up, who was going to give that advice? And so it was a circumstance where we flagged it. We said, I'm going to give you the legal advice, and here's the risk you're taking if you make a certain decision. These are legally dictated features of what you're talking about. And then after doing that, I would go on and say, this is not legally dictated, but here are some factors that as a business matter, I think you really ought to take into account, and it might lead you this way. And so I view that as the right combination, that you ought to signal when you're in each mode. But by all means, if you see something, and particularly if it hasn't been in the conversation in the room, get it out there, because you're still helping your client. And that's an overall feature of lawyering. It's not peculiar to the business environment, is that if you can help your client, do it. That's part of being a fiduciary.
I mean, I guess one of the interesting questions comes up is what if you see your client, I mean, you give them the legal advice, but you sort of also see them doing something that, in your opinion or your expert judgment, is a bad business decision.
To a certain extent, the business person in the room is the business person in the room. In other words, as long as it's clear that who's going to be accountable for that mistake or that liability should it come true, it was their call ultimately. I'm not the business manager, but I would only reach that point after making clear what all the bad things might be that were going to fall on said person if it went astray. So yes, it's still their call, but hopefully you can reshape what the call looks like in their mind by some of the negative features of what they're doing. It's also true that if in an IBM type environment, at some point we would point that out to their management as well, right? That your branch manager is about to make a decision that if it goes astray, these are the downsides. Do you want to intervene? And so get a second look, you trigger a second look within the business framework.
Yeah. Are there any questions? Did that exchange inspire any questions, or hopefully not preempt any questions, or any other ideas come up in terms of, don't feel shy to ask them, but yeah, Mark.
Hi, Professor Gruner. I just have a quick question regarding the M&A context. So when there's a merger or acquisition occurring, in your experience, I don't know how much you've had with this, but is there typically are there IP lawyers that are specifically brought in to address like the transfer of IP in the merger and acquisition, or is that typically left to the more general transactional lawyers who are, the M&A and private equity experts, et cetera?
Yeah, if the incoming or the acquired company is being acquired mostly for some creative product, absolutely, the status of those interests will be a primary topic, and the acquiring party, if it's got a sense, and most do because they're big companies acquiring a smaller company, that the acquiring company will insist on a review of the IP of the target company, whether that's conducted by specialists that work directly for the acquiring company or is done by outside counsel will depend mostly on the acquiring company, because they're usually in the driver's seat on this. But it would be very foolish to rely on IP interests without checking on their status, because you might just find you got nothing or got something of a major problem character quality, you basically, you bought a problem as well as an asset, and that nets out to much less than what you thought you were going to get. So, and in a related context, we write this, or we address this in the transactional IP casebook that Professor Ghosh and I wrote. When companies conduct initial public offerings, the review by Securities Counsel often extends to the status of key IP. So, if you're trying to raise money for the future growth of a company that is trading mostly on a couple patented drugs, the status of the patents involved can highly affect the value of the company. And so saying something about the status of the patents or any current doubt about the status of patents. If the patents, for example, have been challenged, if they even have a letter in-house that says, we think that your patents are void because, and it lays out a plausible line of attack on the validity of the patents, that's probably got to be disclosed in the securities filings because it's a material issue affecting a very high component of the value of the company. There's a company, Santoris, that is featured in the casebook, which went through a spectacular up and down. It was highly valued initially in a public offering. It dropped almost to zero value when its patents were voided, and it came back to life again when on appeal the patents were restored to validity. So it's indicative of why even a few patents and their validity and shadows on that validity are key topics in public offerings and likewise in M&A transactions.
Yeah, related to that, are there any follow-ups or any other questions about that? Or it's a good question. I'm sure there are others too. So, yeah, Jorge.
Thank you for the presentation, Professor Gruner. I was wondering, when it comes to business decisions, were there any bad ones that you kind of often saw come up or had to flag, or any issues that were often overlooked?
Well, there were issues that were often overlooked. They tended to be ones that caused business people to have to slow down and recheck things. In other words, and there's an image that the lawyers are always the party, Mr. No in the room. Don't do that, right? And it is often true that not taking certain actions is the lowest legal risk course. But that's not what these companies are about. They have to engage in transactions to make money and to do their business and pursue their business. And so they're not there to sit and do nothing. So the question then is how many preliminary issues should be checked out? How many risks should be directly evaluated before things go forward? And so probably the biggest category of business mistakes is moving too fast, particularly where there's a manifest issue and then maybe a little more time and some legal or other review will flesh this out. That was one of the biggest sources of mistakes. Of course, the extreme version of that is not coming to counsel in the first place, which you've really got to emphasize to parties engaging in key transactions that they can't just go forward, or if they do so, the entire risk of what legal review might have fleshed out is on them. And so, people made that mistake, but only once, because when something went astray, it was a very serious mistake in their management chain. And we were reviewed, I think, generally, particularly after a little experience, we were viewed by most managers as a big asset. We helped them avoid major mistakes that would have come back to haunt them. But you have to get them thinking that the lawyer's on their side in a long-term sense.
And there is sort of an obligation of the attorney too, and this goes back to what we were discussing a few minutes ago, right? I mean, it's just as much malpractice not to do something when you could have done something. Or is that being a little bit too assertive or too aggressive as far as a lawyer
you have
goes?
An obligation to pursue the and aid the interests of your client, and you can fail in that obligation by sitting on your hands as much as by leaping forward. My comment in what I was just addressing is more taking that notion into a forward-looking systemic sense. In other words, getting business persons, key managers, comfortable with the notion that involving counsel early was almost always in their best interest. That was part of the forward-looking aspect of how a good, well-run company should be handled. I made that same point with respect to IP interests in the presentation, but it's true for almost every issue area in the law. And of course, a company like IBM had many issues that it encountered regularly, and which getting lawyers involved as new questions came up was usually very helpful to getting the full information on the table that they could then make good choices from.
Yep. Any other questions? Those are great questions. I'm sure people have others that shouldn't be too shy to raise. So,
well, let me offer a couple couple thoughts, and not so much on today's topic exactly, but as you are shaping your legal futures, and I make this having gone through the whole arc of computer-related law and changes in the law accordingly. If I were coming up as a new lawyer, I think I'd try even more than I did to stake out areas that are being driven by important new technology or new legal developments. You know, the whole things related to blockchain. You know, somebody who truly understood not just the technology of blockchain, but the spin-off issues, and there are going to be many, many, many of them, will be in high demand. A few years ago, the area that was in that category was computer-aided discovery, meaning all of the massive litigation and massive record-keeping issues related to what can be found with computer scrutiny of key business records. The issues like that, or areas like that, where new technology and maybe new legal standards are creating new issues and new niches of expertise. If you develop with that new niche of expertise and you build your reputation as one of the key and few experts in that high demand area, your career is on its way, I think. And so as you think about where you'd like to start and maybe what areas of specialty you'd like to pick up, those kinds of thinkings, I think, are very helpful. And then the related point is, well, where do you pick that up? Find a client that has those kind of problems and take even basic employment, whatever employment attaches you to those kinds of affairs and problems, so that you build up some expertise, and then you're a transferable legal asset to other firms that really need that expertise.
And some students that we've had, you know, graduates from the program and from this class, one, I mean, it doesn't even have to be very high tech. One of our graduates is practicing, I don't know what the polite term is, or if there is a polite term, cannabis law. And I think she's working for a startup in Portland, Oregon, in that area. I'm not sure where she got her expertise in that, but that's a separate issue.
Well,
but the point is, there is a lot of need for that. I mean, that's really kind of a really interesting area. And, you know, New York State is, I don't know where we are. I think we've legalized medicinal marijuana at this point, but certainly many of the states have moved a lot further than that. And that has created an interesting niche area. But, you know, just to take another example, we've had one of our graduates who took a year after finishing her JD to get a master's in computer science here. And now is practicing out in Silicon Valley. So those are opportunities like that. I mean, there's not one path, and so it's good to sort of recognize all the different ways in which you know, you can pursue things.
in relation to your graduate who got the extra degree in computer science, kind of related point, you may already have the background under your in your pocket, meaning if you come out of a different field or from a different career path, and you still obviously have the background you learned as experience in that earlier life, you can often use that in legal practice. You can become a lawyer in that industry, or you can become a lawyer on issues that were peculiar to that background, and you can stand out because you know a lot about the relevant field from the get-go. And so I encourage people to use their distinctive backgrounds, because that makes you a distinctive lawyer, and that in turn can start or extend a career in good ways.
Yeah. Are there any other questions? I had one other question, I think, that came out of a comment that Professor Gruner made, but I'd like to get as many questions as I can from the students. Is there anything in the chat? I guess I should check the chat as well. You know, one question I had was, you talked about obviously the importance of keeping up with changes in the law.
Yeah.
How about, what's the role within IP compliance about changing the law itself? I mean, we're always complaining about how software patent law is a mess, and patentable subject matter is a mess, and this is not meant just to be kind of a theoretical question. You could argue that Google has made part of its, I don't know if you want to call it part of its IP compliance strategy, but certainly one of its strategies has, think about the number of very seminal cases that have come up in the last, not to mention the Oracle versus Google just 2 terms ago. So what's your viewpoint on that? It's just Google an outlier? It's just
Google is a very interesting client, and Google has pressed the law on IP. Probably the biggest way it pressed, and this is maybe old history to you all, but the Google Books project was, this is where they scanned many libraries full of books, many of them copyrighted books, on the premise that the database they were creating was non-infringing. And that was a great leap of faith. It has turned out to be largely correct as a matter of the law as it's now been litigated. But at the time they took that step, there were a lot of people who thought, boy, they're just setting themselves up to have a tremendous problem. And so there are clients like that. I assume at the time they took that project, they got legal advice that, hey, this is not guaranteed, but it's a reasonable legal position to take, that this is how it will play out. Whether, go ahead.
Well, I was about to say, I didn't mean to interrupt. Sorry. I mean, talking to Google attorneys, and of course, this is sort of off the record or quasi off on the record, but the view I seem to get is, the priority within Google is to see where the engineering leads and hope the law follows.
Well, and
that seems to be borne out by other kind of accounts about what's going on within the sort of decision making within the company. So, certainly it's worked out well for Google. I mean, I just noticed Meta's stock plummeted today again. So it's certainly doing better than some of its rivals. So.
Well, it's certainly on the Google Books project in particular. I think that's exactly the analysis they had, which is there's this wonderful project we can undertake, and there's some copyright impediments here, possible pitfalls, but the benefits are so much greater than the risks we're going to take on the copyright side that we're going to get good legal advice, and can we construct a viable defense that will avoid liability? Well, yes, but with a questionable guarantee of, that wasn't 100% predicted as a successful strategy, that on balance, they thought that the benefits and importance were worth taking that liability risk.
Yeah.
Again, there are big projects that many companies undertake in that same framework, that there are IP risks, but they're willing to take them because there's a bigger picture at stake. So I'm not sure I've described that as forcing change in the law as much as forcing confrontation of an unresolved issue. The database of the sort of that came out of the Google Books project just had not been litigated as a type of possible infringement. And so they came out on the right side of that litigation. It was a legal unknown with some prediction that they'd win and some that they'd lose. Changing the law in terms of rewriting the law or changing versions of the law that have been rewritten, but perhaps poorly, is indeed part of a good IP lawyer's job, whether it be through advocacy or through some of the IP organizations. I recommend to you the IP section of the American Bar Association, which has a fine magazine and does some excellent programs. And most state bars have a parallel IP section. As an academic, Professor Ghosh and I have written about changing the law a lot, and this is actually a fine segue back to the article that is about to come out in the Syracuse Law Review. I think it'll come out towards the fall, but it involves the Alice standard from the US Supreme Court regarding patentable subject matter, which has been a very problematic attempt by the Supreme Court to change patent law standards, the threshold issue in patent law about what can be patented regardless of how new and non-obvious it might be. If a given type of advance is not patentable subject matter, it's just outside the patent system. And so you would think that a fundamental issue, truly the bedrock issue in patent law, should be defined pretty crisply. And that's particularly true since patent law is about incentives. And so you ought to know when the incentives, the rewards for possible invention do and don't apply. Well, what we've had from the Supreme Court under a case called the Alice case is a standard that has been pretty much a failure on all fronts. The courts can't apply it consistently. The clients can't figure it out consistently. The IP lawyers can't give advice on it consistently. And we've had this now almost for a decade. I think it's about 8 years old at this point. So the article presents this accumulated evidence of standard failure. And then in the second part of the article proposes a solution, which is to go back to a hopefully technology neutral standard. If you think about patent law standards have this peculiar feature is they have to speak to technologies that we don't know about yet. They have to speak to an unknown future. And that's a difficult legal standard to write. But if you, given that the patent law is designed to incentivize technologies that have a certain functional characteristic, meaning they do useful things. That's the one thing we can state about a patented invention is it must do something useful. That the standard I argue for is that, well, what we're looking for is any new advance that has transferable utility, meaning every time you make that advance or undertake that process, it produces the same utility and you can transfer that utility to some new set of users. That's all we're looking for as the threshold characteristic in patentable subject matter. So we'll see if that has any traction with the court. Interestingly, Justice Breyer, who's now departing from the court, was one of the authors of one of the opinions that created the standard that is problematical. So maybe there's an increasing opportunity to come back to the patent law side of the Supreme Court's jurisprudence and give a different answer. If so, maybe this article will have some traction in that process.
Yeah, we're excited to see that article come out, and I think they're probably, I know there are folks on the law review here, and some of them may be working on the article, so that's great. Did you have any last minute thoughts on Oracle? I mean, one of the things that's notable about Oracle is that Justice Breyer did write the opinion, but he didn't address the copyright subject matter issue, right? I mean, the copyright analog to Alice in some ways. Just said, oh, we don't need to address that. Any thoughts about that? Or
you know, software copyright has and the related scope of either copyright or patent protection has been problematic through the growing life of software related products for two reasons. One is that it's primarily protected by copyright, but it's not a literary product. It is a functional product. It speaks to machines and does functional things, and that's the heart of the value of it. And so It's always been an awkward fit to protect software with copyright protections, which were initially developed for books and even visual communicative devices that speak to humans. So that's problem one, is copyright is an awkward fit. The protection under patent law has been controversial, but I think is actually more appropriate in the few cases where software truly has done something new and non-obvious. The trick in the patent side is it's rare that you get that kind of leap in new software. Most software is incrementally developed. It's much like the prior version, and then there's a little tweak. Well, that's probably not a non-obvious extension, and therefore would fall outside of patent law protection for the lack of that non-obvious feature.
Yeah.
So there are different reasons why both patent and copyright are awkward fits to software. But for the rare case of a truly new approach to software that nobody saw before, and boom, somebody has produced a functional version of this new kind of software, that it seems to me is better protected in a patent mode than a copyright one.
Okay. Yeah, well, that's wonderful. Well, we're at the end of the time. And technically, the school has been canceled, so we're kind of
you got to run.
So I don't know. We're really being renegades here right now, because in any case, thank you again, though. Really appreciate it. A lot of great discussion. This is being recorded, so if you want to share the recording, and if anybody has any questions, Professor Gruner, we can hang around for a little bit to take them.
Yeah.
But feel free to email me, and I can pass them along, or can they email you directly too?
Yeah, I was just going to say, feel free to email me at my USC address. Let me just give it to you verbally. It's rgruner, that's RGRUNER, @law.usc.edu. So again, that's rgruner @law.usc.edu.
Great,
I'm
wonderful.
happy to answer any questions you might have. But good luck with your future studies, and stay safe in the snow.
Thank you again, really appreciate it. And for the class members, we're not going to meet next week, but we're going to meet if you want to set up some time to talk about the drafts of your project. And then the week after that, we have another guest speaker, and then I'll have some more prep on the cybersecurity compliance type issues. So thanks again, and be safe out.
So it's less of a question. So the idea of having a holding company with all your IP, that's kind of a way to get